Hey, everybody. Hey, hey, hey. Let me know if you guys can hear me. I moved my microphone. It's like up here instead of down here because it was in the way of my big screen where I have all of my like things that I look at and read, like these documents and videos that we watch and stuff. So let me know if you guys can hear me okay because I did move it. It looks like it's working, but I'm assuming it's working. Okay, good. Thank you, Steph. Thank you, thank you, thank you. Thank you, Morgana. Hi, guys. It's not good morning, it's good evening. Good evening. So earlier today, QB and Steph and Morgana, they were like, is Jenny going live today? They were just kind of chit chatting in our little group chat, And I popped in. I'm like, yeah, I'm going live, but it's probably going to be tonight. I had planned on going live earlier this evening, but husband had other plans that I'd forgotten about. The biggest part of that was coming home from work and mowing the yard. So we have a very large yard, so it's not like it takes a few minutes. I mean, it's like a, you know, couple hour ordeal. But anyway, and the reason I didn't go live this morning or this early afternoon is because kiddo did something to her knee over the weekend. We still don't know exactly what she did to it. You can't see anything wrong with her knee, but she wasn't walking on it. She wouldn't put any weight on it. She was crying with it hurting. So, I think she was just like bouncing off she's a crazy pants, so I think she was just doing kid things and hurt her knee. But she was like all lollygagged up in my chair and was like, can you bring me this? Can you bring me that? Can you bring me this? Can you bring me that? And I'm like, there's no way I'm going to be able to do a stream. Because you guys know how she hollers at me already. This would have been every other second instead of every 4 or 5 seconds, right? So anyway, ibuprofen. She's doing good. She's getting up, walking around on it, running around on it, actually hopping and jumping and skipping, even though I'm trying to tell her to chill out and relax. Don't, you know. But anyway. So okay. Let me go in and say hey to everybody in the cafe. Hey, Chaloon. Good to see you, baby. Setting up your portable AC unit. It's about as hot as I can tolerate. Once it gets to the 90s, I check out. And a plus is learning F finally. Oh, you mean Fahrenheit? Is that what you mean? The F? Still, I love your profile picture. Love it. It's good to see your face. Hey, Steph. Hey, QB. QB comes in and says, hey, everybody, put your DNA all over that thumbs up button. Thank you. While you're at it, like, subscribe, share, hashtag replay for the late crew watching later taters. All right. Hey, Miss King. Hey, Morgana. How are you, Miss King? How are you? Hey, Margaret. I'm glad you're here. Glad you're here. Steph just woke up from a nap. Oh no, YouTube ate your comment, Margaret. Oh no, rawr. Oh, Morgana ate it. Or no, she just nibbled on it. I missed you guys today. It was weird. It was weird today because I was like, I'm supposed to be live, but I can't be live, but I'm supposed to be live, but I can't be live. So, okay, we're going to get straight into this because I promised husband that it wasn't going to be an all night thing. Couple things. I got my coffee. Are you guys ready for some bombshell Karen Reed updates? I know that the vast majority of you already know what's going on, or you've been hearing all the things happening today, seeing all the things, reading, watching all the things. but I had to come over here and talk to you guys about it. I did have other plans. I was going to talk to you more about a Lexi Treviso. I was going to do that today because there's some updates with that we need to discuss, but we can do that this week. But I wanted to get on this because this dropped hard and heavy today. There was lots of documents dropped today. And so I got my coffee. You guys get your coffee. Make sure your coffee's hot. Or iced or whatever, however you like it. Okay. Second little bit of information, you guys, look what came in the mail today. I got my book. I told you guys I ordered it. So I've started it. I did read the only thing I read was the back. And then I read the front and back little flaps. And then I read the foreword that was written by Lisa Kudrow. But I haven't started chapter 1 yet. I'm going to I also got the Audible version of it, so because he reads it. So, I'm going to read along as he reads it to me as well. You know what I'm saying? I'm excited for that, so that'll probably be my nighttime stuff. But let's get straight into Karen Reed, all right? Especially for the replay crew who, want stuff like right now. Margaret said I was all discombobulated without the live and had to do chores. I'm sorry. I know it was weird, right? It was weird. Fahrenheit, yeah, I get it, Chaloon. You guys up there are all in the Celsius and stuffs. All right, so I automatically have the motion to dismiss document pulled up here on the screen because this is the first thing that we're going to take a look at. This dropped today. And it is Karen Reed's motion to dismiss. So I did go through and highlight because this is an 11-page document. And I just went through it and kind of highlighted the spots that I know I wanted to get because a lot of it is also like fluffy legal words that I don't understand. And I have QB on standby because I asked her if she would be able to come up and turn this mumbo jumbo into like English for those of us who don't understand what all of it means. I mean, I can grasp a lot of it, but some of it I'm like, wait, what? And QB is smart with the legal stuff. So, she's kind of like my law nerd. As long as she remembers to say hear you, right, Margaret? And then also we're going to go through this. We're going to go through both Yannetti and Jackson's affidavits, which they're pretty similar, but and then we're also going to look at an order that Bev put out today after the fact. And then last but not least, I think the thing that I'm most excited to share with you guys tonight is a comparison to two different trials in the way the verdicts were read. It's going to make sense. It'll make sense. Okay. It'll make sense. You're not just a nerd. You're a dork, QB. Remember? That was how me and you fell in love. Was because you were being a dork. Because you buy things you don't know what you're buying. That was an inside joke. Okay, let's go. Okay, I need to change it back to this screen. Okay. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, the hear ye court, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. That was a bunch of blah, blah, blah. To dismiss counts 1 and 3. Shoot, that reminds me. I was going to do something else and I forgot. Hold on. It's going to take me forever to find it. QB, do you happen to have a QB, do you happen to have a copy of the verdict form with the charges listed? Because I wanted to go over their the counts again. If you can't find it, don't worry about it. I can look for it. I just hate to take up the time if you knew exactly where it was at. And prayers out to everybody that's in the path of this storm. I know QB is like, you know, she was blah, 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 blah. Sorry, my phone hates my guts right now. So anyway, QB had checked in earlier today and she's like, is everybody good? Is everybody good? And I was like, yeah, but we're not supposed to be getting stuff till tomorrow, apparently. But I was watching JLR last night. This is so off topic, you guys. I can't help it. I get way off topic. Not the storm. JLR last night was storm chasing. If you watch JLR on YouTube, I was worried for that dude. I was very concerned. But all right, let's go back to it. All right, so this motion is to dismiss counts 1 and 3, currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. I wanted to skip through this next section. I didn't highlight that because it's talking about Great Britain and John Adams and blah, 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 blah. Here I've got highlighted perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. See, it's very 1776 in there. I know. Well, but to be fair, every legal document is like that. And they have to put the pretty stuff in there too, you know? I just want the meat and the potatoes, not the flowers and the roses. Here, the very day after mistrial, words, Jenny, words. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms, listen to this, that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. Okay. So, she says it's in Discord. Thank you very, very much. All right. Is it this one? Is it the second one that I want? That's got the 4 different spots on it, QB? That's the one I want, right? Hold on, I have to open this one up in the browser because I can't see it. It's okay, I can't see that one. I think it's this one. All right, so I'm going to go over here. We're going to look at that here in just a second, but I want to get through this motion. Okay. All right. Background here. On June 9th, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of blah, 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 vehicular manslaughter in violation of MGL, blah, 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 and leaving the scene of personal injury or death in violation of blah, blah, blah. A jury trial began on April 16th, 2024. On June 25th, 2024, the jury began deliberations. Okay, and you guys remember they wrote a letter. It's like we exhaustively discussed and cannot come to an agreement. And then she sent them back again, and then they came back again, and then back again, and back. I mean, it was this whole back and forth rigmarole, right? They even went home over the whole weekend to fresh brain it, like come back with a fresh brain on Monday, right? Hold on, I gotta get another drink of coffee. Oh. This is a lot, okay? This is a lot to handle on a Monday. Okay. On July 1st, 2024, when the jury presented a note to the court. Now, this was the last note that they're talking about here. The last note when Bev said that they declared a mistrial. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. See Alan Jackson affidavit, which we're going to see here in a little bit. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. And when they say the court, they mean Bev. Rather, Bev indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court and, without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. Okay. So I have a little bit of something to say about what I just read. I'm going to write this down because this is something I'm going to talk to QB about here in a little bit. And it's in regards to the them not consenting. I'm sorry. All right. So, all right. The following day, on July 2, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that she or he wished to inform him of the true results, him being Jackson. Excuse me. Let me read that again. The following day, on July 2, 2024, Attorney Jackson was contacted by a juror in this matter who stated that I'm just going to say they, wished to inform him of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, which is second-degree murder. Juror A was emphatic that count second-degree murder was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury/death. Okay. Another day later, on July the 3rd, so Jackson got those messages on the 2nd. On the 3rd, Attorney Yannetti was contacted by 2 different individuals, Informant B and Informant C, who had received information from 2 distinct jurors, Juror B and Juror C, both of whom were part of the deliberating jury in this case. I know that's confusing, but what they're saying is you had Juror A who contacted Jackson, and then you have Informant B and Informant C, who were basically friends/acquaintances of 2 other jurors. So, are you guys following? Are you following? Let me know if you're following. Both of whom were part of the deliberating jury in this case. David Yannetti, affidavit 2, apparently. Look at affidavit 2. Informant B, who is an acquaintance of Juror B, sent Attorney Yannetti a screenshot that he or she had received from someone of text messages that they had received from Juror B. In that screenshot, Juror B texted the following to their friend. I'm sort of Englishing this, okay, you guys? It was not guilty. This is their quote, okay? This is the text message that they received from the Juror B. The text read, "It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose." That's repeated. Like, I don't understand. I don't know if they just like wasn't paying attention to what they were writing or whatever, but blah, blah, blah. Double hearsay. I get that. Right. All right. Informant C had been in contact with another individual, intermediary C, jeez Louise, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. I'm assuming when they say co-worker that the guy, the girl, Juror C probably went back to work, was on a Zoom meeting, and he's like, finally it's over, I can talk about it now, and they just discussed it through the Zoom meeting, like before their Zoom meeting act. That I'm just assuming that. I don't know that. That's complete me speculating how it could have went. Join the Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Lord have mercy. We need a whole family tree here, right? Okay. Intermediary C says no consideration for murder 2, manslaughter. started polling at 6/6, like 6 guilty, 6 not guilty, and then ended deadlock at 4 no, 8 yes. Informant C says, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. Intermediary C says she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Let me skip through this part. And then here, this is under the argument A, the jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. So I'm going to skip this first paragraph. And then here it says, here the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. See Alan Jackson's affidavit. Juror A was emphatic that count 1, second-degree murder, was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. On Yannetti's affidavit, it says, reflecting text message from Juror B, it was not guilty on second degree. No one thought she hit him on purpose, or even thought she hit him on purpose again. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing U.S. Supreme Court and Supreme Judicial Court precedents. Precedents. I don't know if it's precedents or precedents. Okay. Down through here. Double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a trial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Miss Reed did not consent to the declaration of a mistrial. Rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. It's talking about a different Commonwealth v. Edwards, 2022. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. I don't know if that's how you say that word. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by a discussion with counsel. Here, there was one obvious alternative. Oh, wait. The record is independently lacking on the second prong as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral, I don't know what that word is, and I don't know what it means, to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. Is this sounding okay? Are you guys coming up with and don't answer the ones that know what I'm planning on doing, i.e., QB Steph Morgana. But is this ringing a bell like something that somebody that we've seen previously happen that should have happened in this trial? Do you know where I'm going with this? Do you know what two trials I'm going to compare here in a few minutes? Such inquiry, in effect, implies that we should consider conviction on the lesser count. No similar danger is present, whereas here, the jury was asked to return three separate verdicts on three separate counts. In this circumstance, where the jury reports a deadlock without specifying the count on which it has reached an impasse, it is a straightforward follow up to ask whether the deadlock relates to some as opposed to all counts. Relates to some as opposed to all counts. Miss King, what are you thinking? What are you thinking? Which one are you thinking? Um And then here it says, alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communications with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, the defendants ask for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that. You're right, Miss King, 100%. Yes, ma'am. That's the one I'm going to talk about. There you go. Absolutely. It was the first thing I thought of. I was like, wait a minute. That's exactly what they did here. Why didn't she do that? The tale of the two Karens, right? Oh my God. Oh, did you say that too? I didn't see it, Margaret. It's similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. Oh, out loud to yourself, Margaret. I got you. Out loud to yourself. Just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Miss Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy clause. Well, I mean, Miss King, that's a great question, but I feel like if they didn't do it that way, then the lawyer that filed this motion on Yannetti and Jackson and Karen Reed, like on their account, wouldn't have filed it. You know, I mean, I feel like they got a leg to stand on, or they wouldn't have even tried. Hey, Melinda. Okay. So, conclusion, for the foregoing reasons, Ms. Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3. Hey, Cherie. Um, so this lawyer that they've got here is Martin Weinberg. I don't know who he is, but says I, Martin Weinberg, do hereby certify that on this day I have served a copy of this motion, blah 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 blah, and attached affidavits on Assistant District Attorney Adam Lally via email. So, um, that is that. Now, I have um I'm kind of wondering, let me look real quick. I'm looking to see if this is one that I need to do. I mean, hold on a second, folks. QB, do you know if the affidavits are basically like pretty much says the same thing? Because I honestly didn't look at the affidavits. I kind of skimmed, but I didn't like read the entire things. And so I didn't know if basically everything they said in their affidavits is what was said in the motion. Mm, it does. They do look a little bit different. Hold on, let me show this tab. This is Yanetti's affidavit. Okay. So we'll just kind of scroll through this. This is his affidavit that they attached to the motion to dismiss the charges. Similar but different. Jackson was contacted by one and Yannetti by two others. Okay. Well, I was reading through and it seemed very similar words, but then I was like, well, but then I read something that was a little bit different. So on Yanetti's here just goes through number one, his license in Massachusetts. Um, I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. Let me get a drink. I'm sorry, QB. She's like, you gotta give me a chance to type. I'm still one handed. I'm sorry. So, whenever you guys see me in the mornings, I'm only like 1 or 2 cups of coffee in. At this time of the day, I'm several cups of coffee in, right? And so I'm like, all right. So, number two says on July 3, 2024, I received communications from two different individuals. We know that part. Number three says, to my knowledge, informant B and informant C do not know each other. You're like, do you? And oh, let me look. Oh, I look more refreshed. Yeah, Steph. It's usually because whenever I come on in the mornings, I've been up running ragged with my child all day. She's crazy pants, man. Let me see. So number four, they're talking about the screenshots she had received from someone, text messages. Oh, okay, now this one's interesting. We didn't read this earlier, and I do want to read this part out. Number four, I'm going to read the whole paragraph. It says, on July 3rd, 2024, informant B sent me a screenshot that he or she had received from someone of text messages intermediary B had received from juror B, blah, blah, blah. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree. Excuse me, and split in half for the second charge. When the judge, listen to this, when the judge sent us back with that Hernandez thing, talking about the Tui Rodriguez, wasn't it? Or was it Tui? I thought it was Tui Rodriguez. Anyway, they said when the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. Okay, it was Rodriguez. Okay. Um, when the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. Hold on a second. My Discord's going off. Oh God. Hold on. I'm gonna have to. How can I turn my notifications off from the computer, or at least the sound? I don't know how to do that. Let me just X out of it for now. Okay. So where was when the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. And that's what we talked about. We talked about that. Remember, we were talking like, what are they going to do? Go back there and just beat each other about the face and neck, about the head and neck until they get what they want, the one to, you know. Um, I thought, and then they continue on. It says, I thought the prosecution didn't prove the case. This is a text message now from a juror to an acquaintance of theirs. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Again, that double sentence. They gave us free counseling forms when we left. Based upon, okay, number 5. And then they went from 6-6 to 4-8, right? Based upon the first name of juror B given to me by informant B, I believe I'm able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. So they knew that he wasn't like a alternate juror, right? Okay. Unity. That was 5. Let me go over here to 6. On July 3rd, informant C contacted me to say that he or she personally knows juror C as they used to work together. Informant C and juror C also have a mutual friend who is a current coworker and friend of juror C. Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday, July 1st. He or she told me that he or she believes that post led intermediary C to text him or her and inform them that juror C was a deliberating juror on the case. Informant C told me that they thereafter reached out to juror C via text message and discussed their experience as a juror in very general terms. They discussed what an exhausting experience it was and that juror C was relieved that it was finally over. Number 9 says intermediary C told informant C that juror C, Lord have mercy, would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. And number 10 says today, informant C sent me 3 screenshots of a text message exchange they had with intermediary C. Informant C told me that the intermediary was reporting to him or her during this exchange what the juror had revealed during the Zoom meeting. Text message exchange reads as follows. Okay, can you guys see this? I don't know if you can see this or not right here. This is where we're at here in the center. No consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4 no, 8 yes. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, they voted no because the cause of death was twofold of hypothermia and head injury, of which they were convinced that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end. Oof. Oof. The whole jury felt very intimidated by Higgins' presence at the end. He or she is not sure what he or she's going to do. They're going to lay low for a couple of days and see where it takes them. Hasn't ruled out anything. The jurors all have a group text going. And then the informant that actually spills all this. Oh, Albert, not Higgins. Okay. Well, I did see somewhere that they said that Albert being there on that last day. Okay, now I see what you're saying. But it did say Higgins, but I did read where they said that the jurors were very intimidated by Brian Albert being in there on that last day. Okay, and then the person that messaged the lawyer says, interesting, if it was no consideration for murder 2, let me rephrase that. This person isn't messaging. This is just her reply or his reply. I don't know if it's a him or her. Their reply back to the person that they got this information from. This is so confusing. I know. They'd said Higgins, but probably meant Albert. Higgins wasn't there that last day. Right. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict. Slip. That was all confusing. Talking about the verdict slip, right? And then intermediary C responds, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. And the informant says, what a great experience for them. The juror. Amazing that they let the Alberts in the last day. And the intermediary says they felt very honored to be part of it. He or she was. And then it says redacted physical description of juror C. I don't know if it would have been something like stoked or nervous or excited or whatever, but everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Informant says that's the way it should be. O knew it was an intelligent jury. They will be studying this case in law programs for years to come. How not to investigate and try a case. Oh, i.e., how not to investigate and try a case. If they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. All right. Now that's the text message thread between the informant that told Yannetti that they had a conversation with the person, and the person is the intermediary who is a friend or coworker of the juror. Okay. Totally a he said, she said, they said, we said, you said, they all said, y'all said, right? So, number 11 says, based upon the description of juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. Signed under the pains and penalties, blah, blah, blah. All right. So, I'm going to go over here to this one. Now, this is the affidavit of Alan Jackson, okay? Partner of a law firm in Los Angeles, Worksman, Jackson, and Quinn, blah, blah, blah. Appearing on behalf of Karen Reed and Commonwealth of Massachusetts, blah, blah, blah. On Tuesday, I was contacted. Juror A told me that it was seeing inaccurate reports about the split. Number 4. Okay, that was all. I already knew all of that. We already discussed a lot of that. So let's see. This is where they discuss about the not guilty. Everybody was adamant that everybody agreed it was not guilty. Number 9 here says neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Margaret says, good thing I had a nap before this. Weesh. The SIC, the sick, I always thought that meant that was like verbatim what they said. Like, I don't know. There's some in there that is important. RE Juror A. Okay, let me go back up. Okay, let me go back and let me do this over. Hold on, you guys. The reason why they contacted. Okay. Let's go back then and look. I was contacted by Juror A. I'm here on number 2. True name and identity withheld to maintain anonymity based on my conversation with Juror A and that juror's description of who they are and where they were seated, and certain identifying information like name and occupation disclosed during the voir dire process, I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the split. among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it is important to disclose such results because he or she believes that those results significantly impact Ms. Reed's rights. Number 3, she said number 3. You're behind QB, ma'am. Yeah, because they were all over Twitter, right? Like I was seeing numbers all over the place. It was like 12-0, 9-3, blah blah. I mean, it was like the numbers were all over the board. She says, "No, I'm not." Okay, I was just making sure. But jury told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1. She was emphatic that count 1 was off the table. And she was also saying that the jury also unanimously agreed that Karen Reed was not guilty of count 3. So it was count 2 that apparently that's where they had the split. Okay. And kiddo is running through the house blowing a whistle. Can you hear the whistle, you guys? Can you all hear that whistle? Oh, Jesus, Jesus, Jesus. I'm going through this. I don't want to have to number 11 says, nor did the court on its own inquire of the jury foreperson on which counts the jury was at impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Number 12 says, had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and count 3. Miss Reed was denied her right to receive those verdicts in her favor. That's not a whistle, that's her bad knee, right? All right. So that was it for the affidavits. All right. I'm going to drop this link. I know you do, QB. I'm getting ready to drop this link, ma'am. Hold on. Copied. You have words and I have questions. So, QB. Here's the link. I'm putting link. Here's the link. While she's coming in, I'm going to mute for just a second. I'm here, but I'm got to grab something real quick. Hi, ma'am.
Hello. You know you're torturing me, right?
Why?
Because I can't type.
Am I asking too many questions too
quick? And I have all these words. And you're like,
well,
Well, hey
Well, what?
QB, well, did you do this? And I'm like typing, and you're like, oh, let me just go look for it. And I'm like, I typed like 4 sentences with one finger, and now she's gone.
I'm so sorry.
Like, dang it.
I'm so sorry. I'm so sorry.
Dang it.
She's a one-handed
Anyway,
typer today. She has been a one-handed typer for several days.
yeah, and it'll be several more. Um,
Ugh.
anyways, ask me questions.
I want to know. Hold on just a second. Hold on. I got to
Okay.
finish this up real quick. Hold on. Give me 2 seconds.
Hey, y'all. How y'all doing? Oh, story time. So my child comes running in and says, Mom, what's the law on? And then stops. Yo, don't be running in the house asking me what the law is and then not tell me what the law is that you want to know is. He wanted to know about a box turtle.
What's
He
the
wanted to
law?
know about
Oh,
a box turtle.
because he didn't know if he was allowed to have one or not.
No, he didn't know what the law is here about touching them, which is you ain't allowed to. Now, if they're in the middle of the road,
Oh, wait. Why did that happen?
what?
Sorry.
Okay. Nice feet, Morgana.
Hmm.
Um, if they're in the middle of the road here, you may pick them up and move them in the direction that they're traveling.
Hmm.
If they're in our breezeway, you just need to leave him alone. Let him go wherever he's going. He's not going to get hurt.
Didn't you tell us that the other day about the turtle, about you have to
Yes.
put them in the same direction? Well, how do the
Yes.
cops know that you're putting it in the same direction?
I don't know.
Uh,
Somebody would squeal. Let me
who?
tell
The
you
other
what.
turtle beside of it saying, "Yo,
No,
he's with me."
the other people that saw, they're like, he was clearly heading north, and you turned him going south.
Oh, I would love to. What are those turtles? We're getting way off subject. What are those
Red-eared
turtles
sliders.
that come up in the sand and then like waddle to the beach? But it happens like
Oh, we
certain
go see
times of
them
the.
all the time. Those are sea turtles.
Mm, they're
Yeah,
so
we watch
cute.
them. As a matter of fact, I just had it come up on my memories because we went out to see one on July 4th, 7 or 8 years ago, and the mama's name was Liberty,
Oh,
and she laid like 150 eggs. Yeah, we used to be on sea turtle watch.
wow, that's cool.
Yeah.
I would
Anyways,
like to watch that. Okay, so my question is, how are they saying the defense? How are they saying that they weren't given that they didn't consent to the mistrial whenever they
okay,
literally consented to it?
okay, but they didn't consent to it. They just didn't argue against it, and there's a difference. And here's what I think happened. Okay, what I think happened is it all happened very quickly. Okay,
Yeah,
and
it
everybody
did.
was like, "Yay, we didn't get a guilty verdict. We're all happy. We're hugging everybody. Paul's threatening people." Um, and they're like, "Yay!" And then when the fervor died down, they went, "Wait a minute. Wait a daggone minute."
Mhm.
And when so because she did not come out there and read the note like she had prior. Okay, and
Right.
then said they're deadlocked or at an impasse. What she did was she came out, she said, "They're at an impasse. I'm calling them in." She called them in. She's like, she read the letter. She gave nobody a chance to speak, Lally or the defense. Okay. And she said, "I'm not going to do that to you. I'm declaring a mistrial. You're dismissed. I'll be in to see you in a minute. Bye."
Yeah,
And they were
yeah.
gone.
Mhm.
So now in Massachusetts, they don't do necessarily a poll per se of the jury, meaning like they don't go, "Hey, do you want them do you want them polled? At the end, like when they say, oh, it's
Right.
guilty, and they go, do you want them polled? And they go, yes, that was my vote. Yes, that was my vote. Okay, they don't do that in Massachusetts. But what they do is, I have voice, can you tell? Do.
Yeah.
What they
You do.
do is they can say they want confirmation on if they're hung on all counts.
Mhm.
Okay. Now on the flip side of that, even though the jury forms were, I won't say extremely, but they were a little convoluted. Okay.
Well, yeah, we're gonna look at it here.
So but 1 and 3 were not. 1 and 3 were very easy. Is she guilty, not guilty of second degree murder? Is she guilty or not guilty of leaving the scene? Those are very easy. So the thought is, if they decided on that from jump and they were only stuck on part 2, why didn't they fill those forms out? Because that would have clarified it,
Mhm.
right? So then that makes you think, well, maybe they weren't. Maybe they were held out on all of them. What I think happened is, I think they said, we know it ain't second degree, so we'll table that over there because we don't even need to talk about it. What do y'all think about leaving the scene? And everybody was like, "Nah, I don't think that happens." They put it over
Mhm.
there, and so then they got to deliberating on the one that they thought that they were going to stick to, the meat and
Right.
the potatoes. Okay,
Right.
and then again, everything happened so fast. So when they sent that note back again, she was like, I'm declaring a mistrial. I'll be back to see you in a minute. And that was that. And nothing got done because for them, that in their minds, they know that they've made a decision on that and that they're deadlocked on the second degree.
Uh-oh, she dropped. She'll be back. There she is. Hold on. There you are.
Sorry.
That's
I
okay.
don't have my computer up because I only got one hand and I'm just not doing it. So uh so in their mind they had already decided on that. So I don't think that they necessarily filled it out,
Mhm.
or didn't fill it out. Like, I mean, because in their mind, like they didn't even know that she was gonna what she was gonna do because she had already sent them back several times. So all of a sudden she goes, "It's a mistrial, and I'll come back and see y'all in a minute." Well, for them, in their minds, they've already said that they were deadlocked. They assume that she knows that they're deadlocked on number 2, that it was easy, number 3, 1 and 3. And for them, it's no big deal not to fill out that form. But for Karen Reed, it's huge
Right.
because here's the difference. They didn't fill out the form, they left. Okay. So everybody's like, oh, it was 10-2 and it was 9-3 and it was this, that, and blah, blah, blah. And she could be retried on all 3 and yada, yada, yada. They
Mhm.
can go all day long. Every juror out there can walk out and have a press conference and say, we did not think she was guilty on 1. We did not think she was guilty on 3. But because that form wasn't filled out and signed, it don't matter. It doesn't matter. They could have 6 jurors come out and have a press conference and say, we all agreed that she was not guilty on 1, she was not guilty on 3. And because that form is not filled out, it doesn't matter. Now, if Lollipop had any ethics, then he would go, "Oh, I probably shouldn't try her on those because they really didn't think she was guilty on 1 and 3." And so that's double jeopardy.
Mhm.
Can't try her for something she's been found not guilty for. But by law, because they have not filled out that form, it does not matter. Where the problem lies is where I was saying number 3, the number 3 thing. If she were to call them back, okay, she would literally have to say, you can only answer based on what your mindset was on July 1st when you know,
Yeah,
blah
but
blah blah.
that's about as
It's
valid as saying, "Oh, well,
disregard.
strike what you just
Yeah,
heard this
I know.
person
I
sounds
agree with
saying."
you. But that's what I'm saying. So now it's totally effed up because, and that's why I said this. I don't know if it was you or if I was on Twitter with Sleuthie. We were having,
Sleuthie has
not,
been on it all day
she
long.
is
Like, she
over
is
them. She's over them.
yeah.
And she's not wrong. She's not
Mhm.
freaking wrong. And Coffin Deffer, I don't know what she's smoking. She needs to get off that pipe. Like, seriously. I don't
Yeah.
understand. Anyways, um, but this could have easily been fixed by Bev doing her due diligence and saying, "Were you hung on all three? I don't want to keep y'all. Y'all have worked hard. Y'all have worked, whatever. But I just need to know, were you hung on all three? Were there any that you decided? And we need to fill, girl, you can go ahead and throw that up because you know it. I ain't wrong. I ain't wrong.
I only did
Um,
that because of the Coffin Duffer
I
comment,
know,
but
that's fine. Coffin, come at me, Coffin Deffer.
okay.
I got you. Bring it. Um,
She did work for the FBI, but, I mean,
has any? I want to know. Has anyone confirmed that? Has anyone checked her credentials? Because
oh,
she's no, because she's over there going. Well, I mean, okay. Yesterday, as of yesterday, she's talking about how Proctor was a patsy, and um, and he said some bad things. Now today, now that he been gone without pay, now she's like, well, yeah, he's got to pay for them things that he said. Well, which one is it, Coffin Deffer?
mhm, yeah,
Anyway,
I
let's
know.
get off of her because I'll get mad. At the FBI, you're right, Steph. That might be it. I'm just saying. I don't know, like, who checked her credentials, but she's all, I'm the FBI, I'm the FBI, I'm the FBI, and your FBI people came up there, wrote a 3,200-page document about their investigation, and they said she didn't hit him with the car.
Yeah, I know.
And you're sitting here telling me that Trooper Paul was correct and he got sideswiped. It wasn't a direct hit. That's why he didn't have bruises. Come on. Come
Mm,
on. Anyways, yeah, Bev should have clarified. Bev should have clarified. And she might have gone back and said, hey, were you this, that, and the other? And if they said that, then she should have had them fill out that form.
right.
But
They
we
should have
don't
filled it
know.
out anyway. They should have
They
had it
should
filled out
have.
anyway.
But look, Jenny, think about it. You've been on this thing for 8, 9 weeks, right? You've listened to Lollipop go, what if any, who, what, where, when, why, if any.
Mhm.
And she's like, I'm declaring a mistrial, deuces. They're like, see ya. And I mean, they're not thinking about that paper because to them, they said their piece.
Right.
They gave their ruling, and to them, it's no big deal. Okay, we agree that we don't think that she's guilty of count one. And I'm not saying that they don't think it's a big deal. I'm just saying that it's fast and the whirlwind of how everything ended. It's easy to see where that could get missed. Bev's job
Is to make sure it don't get
is to
missed.
make sure it doesn't get missed. And on top of that, and I love me some Jackson and Unity. I got their shirt. Okay,
I still have to get mine.
It
But they
was
should have
their
been on
it
top
was
of it
their job.
too.
It was their job. Yes, it was their job. And like I said, I think it was just a whirlwind and everybody was like, "Wait, what?" And and they're like, "Okay, well, it's not guilty. Great." And then the dust settled and they went, "Well, shoot." I think when it hit them was when the Commonwealth came back so fast and said, "We're going to retry her."
Mhm.
And they went, "Well, wait a daggone minute. Can they retry
I'm
her?"
not sure because you know that they don't play checkers, they play chess, right?
I know they do. I know they do.
But
I know they do, but I don't know. I just
and there it should be a rule. Even if it's a mystery, even if you guys cannot come to a decision, this paper has to be filled out
and
before
it's
you exit this room.
And it's Bev's job to make sure that gets done.
And
She's the
maybe she's gonna
gatekeeper.
fire the bailiff, whoever takes care of the jury. I don't know,
She went
but
back, but she went back there to talk to them.
yeah, afterwards.
Yeah, she went back there to talk. It doesn't matter if it's afterwards. They had not left the building.
Right, right, right.
So until they leave the building, it's fair game. And it's her job. And don't get me wrong, I think Unetti and Jackson dropped the ball as well.
Mhm, mhm.
But
Lally's just sitting over there like, "La da 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 da,
la
da da
la
da
la
da
la,
da."
I'm gonna do it again because Morrissey says I have to. Um, and
Mhm.
he's just like, great, I can go have a pack of cigarettes
Right.
or a carton of cigarettes or whatever. Um, and they all wanted to get out of there to go to Cape Cod. I mean, it's the fourth. I don't know. I mean, I think there was I think there was a comedy of errors. I think there was a lot of things that happened. And it could, you know what? It could very well be that Unetti and Jackson were like, that's fine. We'll just file a motion. The problem is that now, if you bring these people back, you
Their
can't
opinions are
guarantee
tainted because they've
their
heard what
opinions are
every
tainted. Yes. Now,
YouTube person or every article, every tweet,
yep.
they've seen the
And they
public's
ran out there and read everything.
position,
Daggone well, the first thing they did was like,
hopped on the
let me
internet. They
see.
got
Yep. Let me
straight on
see the Twitter.
YouTube or
Let me see
Twitter.
the. Let
Yep.
me see the Twitter. Let me see what's on the Twitter. Let me see what's on the
Mhm.
YouTube. IG. Where are
Well, I
they
mean,
at?
I
Where
would have. I
I
would
I
have
would
done
have
that.
too. I would have too. Heck, I might have just been. I might not even have been looking for the case. I've been like, dang, what my girl been up to? Do you know what I mean? Like, them people you
Mm.
only have connection through Facebook. You're like, dang, what's she been doing? Because
Right,
I ain't been
right.
on here. But yeah, I don't. I mean, I don't know. But here's my personal opinion. Now they keep showboating and they keep going. Now we don't care if Proctor got left without leave or without pay. We can't wait for July 22nd to get a new hearing date. Brr, brr, brr. I don't think I think that they will showboat that they are going to retry the case because their pride won't let them say otherwise. But
Mhm.
I think at the end of the day, you can throw my thing back up there. You never know when I might say something. Um, but I think that at the end of the day, the very very end of the day, when the FBI stuff comes out, when they don't have Proctor, because Proctor's going to get on the Brady list and he won't be able to testify.
Mm.
So then what do they do? I mean, they can have all them people all day long come up there and say, "Well, we worked as a team and we did this." You see, at the end of the day, they had to put him up.
Right.
So, I mean, how do they bring a second case? And I think the whole thing is I don't see. I think they will try to bring one. I think they will say that they're going to bring one because I think that their pride and their ego won't let them not bring one. But I think when it's all said and done, they're not going to be able to.
Yeah.
That's my
Well,
opinion.
and don't they have like a year to get it back
Yeah,
on the
yeah,
book,
yeah,
back
yeah,
on the schedule
yeah. So
to retry?
that's an interesting thing because you're going to do David Swift and you're going to against Karen Reed. But here's the interesting thing about David Swift. So in the David Swift trial, they did the same thing. They had three things, and they're like, no, he's not guilty of second degree. No, he's not guilty of this one. We're hung on this one. But the one they're
Mhm.
hung on, the statute of limitations is up.
Yeah.
So if
That
it
was
was
on the
murder,
voluntary manslaughter. How can they
right, the
have a
involuntary,
no, it was voluntary manslaughter.
yeah, voluntary manslaughter. So murder doesn't have a statute, okay? And there's certain essays that don't have statutes anymore,
Okay.
okay? But everything else has a statute of limitation. So now you're looking at it's been over 10 years. 10 years is a typically a for the bigger things is typically a common statute is 10 years. So you're 11 years in. So how can they retry him only on the voluntary because they can't bring that charge separately without the murder charge. That carries no statute. It's very interesting, actually.
I don't know, but I mean, and that's one thing here that I'm like on this on the Karen Reed thing. Like we're looking, I got the charges pulled up here, so it says 1, 2, 3, 4, but one says not guilty. The charges
Right.
are the first charge,
One is the top charge.
the guilty, the manslaughter while operating a motor vehicle under the influence.
Yes. That is number
Okay,
one.
that's the one that they say they all agreed that she was not guilty on. Then
No,
they say,
no,
huh?
that isn't. No, 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 you're confusing the two. The one, the first charge is the second degree. That's on a separate sheet of paper. They agreed that she was not guilty. The third charge is the leaving the scene. That's the third sheet of paper. They agreed that what they're hung on is this entire charge right here and what part of it she's guilty of.
So wait, where's the other ones? I couldn't see those that you sent me.
Yeah, the first one is the first degree. It's on Discord has been acting a whole fool.
No, when I tried to open it, it was like this big, and I couldn't even get it to like
Oh
get
Lord, I'm looking at
magnify it.
freaking toes. Okay, the first one is offense one, murder in the second degree. Okay. And that is one of the ones that they said that they agreed that okay, that Yannetti and Jackson are saying, because understand this is still all allegedly.
Right. Yeah. I
Um,
mean,
and
if
it's
they do anything,
important.
they're gonna have a
Well, what's important to point out too is that if it was just Yannetti's people, basically Bev could just go, yeah, that's hearsay on top of hearsay on top of hearsay. And no, Jackson's is the one that gets them back into court because it's the actual juror contacting him.
okay. Yeah.
Now, mind you, juror B and C, who got informant, who got, intermediary to tell informant to tell the people, they may have done that on purpose. They may have said, hey, give this to so and so to give to so and so. So it's like 7 degrees from Kevin Bacon, and they don't know who we are, right? Do you know what I'm saying?
Right.
Like we gonna be like 3 degrees out, so they can't figure out who we are. Which
Oh,
which
that's funny.
which leads into her thing that she did today, which I now the impoundment she did today.
Mhm.
Um, but that covers them and protects them, and I'm sure they're scared.
Yeah.
I'm sure they're scared, and I've been saying this from jump. Then McAlberts, there's more there. They like a mob family, okay?
Mhm.
And those, I think that the people of Canton are scared of them. And I think that's
Probably.
why, and I said it before, was why they brought them in there. And then Paul went on and did that interview and said, "Yeah, I brought him in for that.
Mhm.
Yeah, I brought him in for that."
Yeah.
And so, but yeah, so this one that you have up on the screen right now is the only one in question.
That's the one that they didn't. This is the one that they didn't agree on.
Yes, but it's the whole thing. It's the
Okay.
entire thing. They
Okay.
can't decide on one, two, three, or four of this charge.
Okay.
And so some were probably like, maybe number two, and some were like maybe number four, and but they couldn't come to an agreement. All 12 of them decide on one of them, which kind
Well,
of is weird to me.
somewhere I read that that there was someone who couldn't say not guilty because she was drinking and driving, and they couldn't let that go. I
Yeah,
don't
so
know if that was true.
there was a lot of speculation on that. The one thing that got me was I don't remember if it was a it wasn't A, it was either B or C. but they said that they couldn't vote guilty because they couldn't see where the vehicle caused the hypothermia. And I'm like,
I saw that, yeah.
what
Mhm.
what because if
Yeah.
you say that if you're saying that you can get to that the vehicular part of it, well, then that leaves him in the snow, which led to the hypothermia. So I don't understand. I don't know. There was a lot of confusion in the wording. Like there was the one that said, "We're not even sure she hit him on purpose or if she hit him on purpose." And it's like,
Mhm.
what? And
Yeah,
what
yeah.
I think they meant, and I mean, I could be wrong, it's total speculation, but I think they meant we weren't sure that she hit him on purpose or that she hit him at all.
Right, 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 right.
But it kinda got jumbled. So I don't know. And I'm not gonna lie to you, even though I think Bev might be covering something up, I think that her doing that impoundment today was probably one of the best decisions she's made.
Well,
Because
and
at
I
the
was
end of the
like,
day,
my
they need to be
question,
protected.
let's look at that real quick because, um
It's only for 10 days. She can renew it,
yeah.
but
Yeah,
it's
yeah,
only for
yeah.
10 days.
Yeah, I saw that they said it was only valid for 10 days or whatever,
That's typical. It's kind of like when they do like protective orders and stuff like that. They're valid for this amount of time, and then they have to be renewed or um, depend on your state. But
hold on, I'm looking.
I just I want to tell and I think I might have mentioned this to Lucy, but I want to say it again. And I get where she's coming from. But at some point, if we just stop giving all these people our energy, don't they have to just go away?
Oh, yeah, I mean, and that's the way it works. I can tell you, I coulda told you that forever
I
and a
mean,
day ago.
just I mean, I haven't responded. I mean, I'm like, you tell them, Sluicy, but I ain't responded to none of them because they ain't worth my time, my energy, or my breath.
Exactly, and that's all they
Um,
want. They want
and
an
that's all they
argument.
want. And it's like,
Yeah,
Sluicy, just she
just
the problem is that she has done a deep dive into Sandra, okay?
mhm,
And
mm,
she's doing her timeline like she did on Karen Reed,
mhm.
and she's angry.
Right. Well, I mean, I get it. Um, whenever I started looking at it the other day,
Yeah, it's awful. And that guy, I mean, that guy and his wife, the girl that disappeared, I can't ever remember their names, but it could be that the guy didn't do it, or it could be that the guy did it, but he's gonna walk free because Proctor investigated it.
oh, yeah. Yeah, yeah,
And
yeah.
there's a crap ton of crap, a whole crap on that
I know
investigation as well.
Patricia and Steph keep talking about that case too, and I've
Yeah.
never followed that one. Um,
So Proctor is the lead investigator on that. Okay. And
yeah,
there is a whole crap ton of crap wrong with the investigation. And they say that they're not sure. I mean, I don't want to disparage nobody, but they're saying that they don't know that this guy had the wherewithal to pull this off. Let me say it that way. Okay.
yeah,
Um, and so either he didn't have the wherewithal to pull it off, and Proctor Walsh, thank you, and Proctor made it up, or he did and Proctor messed it up and he's gonna walk away.
yeah.
And why okay, all right, while we at it, while I'm on my soapbox. Why didn't the Massachusetts State Police take Proctor off of everything when they realized if they're saying, "Oh, it's the text messages that were so bad." It's not anything to do with the investigation. It's just the text messages. Why didn't they pull him off of investigation? Because he never would have been assigned to Walsh if they would have pulled him when they found out that he was a whole POS.
Yeah, I don't know anything about that one.
They should have pulled him off of everything. When there was any question, when the FBI stepped in, when the IA stepped in and all that stuff, they should have pulled him off of everything. Just in case.
Mm,
Just in case. Because one of two things is going to happen. Either an innocent man's going to go to jail or a guilty man's going to walk free
Well, and
because of
that's
this
like with
man.
me with the Swift case, I mean, I believe that David Swift character did um kill his wife Karen. I think he did, but they didn't prove it.
They didn't
Uh,
prove it.
mm-mm. And they waited too daggone long. I'm sorry. That they waited too long
Well,
for
and
that.
that's
Whenever
okay. So
they
that
didn't go ahead, QB what?
and that's why all of this whole statute thing is so interesting because had they not waited that long, one, they may have had better evidence, okay,
Yeah. Mhm.
and they may have had better eyewitness testimony and all of those things. But two, had they tried him and he was found not guilty on all the things, but the manslaughter, okay, then they could have recharged him right away because the statute wouldn't have run.
Right.
But for me, I mean, for me, all of this stuff is like unprecedented times. Like the whole hung jury, and the one thing that they weren't hung on is the one thing they can't recharge with. When have you
Mm,
seen that? I ain't never seen
mm,
that. And this stuff with Karen Reed and the stuff with Delphi, and now the new thing with the NFL people and the parents, and they're just that whole thing is crazy.
mhm.
I don't know what they did or didn't do, but what I know is that Indiana, I don't mean no harm to any people that live in or near Indiana, but Indiana's crazy. They're crazy. They're hiding something.
I know Delphi sure has a lot of stuff going on.
Okay, well, this mirror thing, and I haven't deep dive, deep dived.
Deep
I
dived.
haven't, but what I've been seeing, what I've been seeing is that they are kind of like not as much as Florida, but similar in that they post their stuff on the Indiana court's website, and they're saying that all this mirror stuff. You know who I'm talking about, right? It's the NFL player and
Yeah,
his
yeah,
wife
yeah.
and
His
the
name starts with
14-year
a
old.
B or so yeah.
Yeah. Okay. So they're
I mean, I don't
saying
know the story, I just saw headlines of it.
that everything's under lock and key, okay, and nothing's been done, but they've already had hearings, but there's nothing on the court website. And so they're
Mhm,
like, and there's no bond been given.
mm.
And so the attorneys for the Muirs are like, they're holding them basically hostage with no bond or anything. I mean, it wasn't a murder. It's not a murder case. It's not like they don't get bond.
Yeah,
So
right.
it's actually very interesting. But anyways, the funny thing is that all this stuff has been going on for years and years and years and years. We're just now seeing more of it because of social media um and the peoples.
Yeah. Well,
Morgana, I love you. That was in Discord. Sorry, I'll be quiet.
so over here, I just pulled this up the screen. This is just a short and sweet, basically Auntie Bev, um, came out with an order of impoundment today. Basically, all this document says is that she's basically holding the list of the jury names hostage for the next 10
Yep,
days. Nobody
for
gets it,
next day.
nobody can see it, it can't be publicized, blah blah blah. But the
Well,
thing
and there's
is that's not the same as like a gag order on the jurors. The jurors can go out there and still continue to speak, right?
yeah, so they
They
can
want
go,
to.
they can talk, but they can hide behind juror A and impoundment
Right.
A, and they can, or informant B, and they can hide behind all of that. All that says is that okay. So, and there's some question to that too, because it says that okay. Usually, how it happens is if a jury comes to a verdict, then once the verdict is filed with the court, the list of jury names is released. But technically, they didn't come to a verdict because no verdict form was filled out. So
Right,
then
right,
it's
right.
like, so is it, did they come to a verdict? Should it be released? How does that work? Do you know what I'm saying? And then the more contentious part of it is, which I think people are making more of this than what it is. So her last case ended in a hung jury. Okay.
Right.
And I can't remember the case name. But immediately upon filing that it was a mistrial, she released the jurors' names. And everybody's like, well, you released the jurors' names in that thing. Why aren't you releasing them here? Well, there's a reason why I can't remember the name of the case because nobody knew the case. Nobody knew of that case until Karen Reed.
Mm,
So
okay.
my personal opinion is she released those jurors' names because it wasn't a threat.
Right.
There wasn't a threat to them
Well,
like
and they've
this.
already said that they felt intimidated by Brian Albert being there that last
Yeah,
day.
yeah. I mean, and the fact that I'm trying so hard to have grace for his family, but the fact that Paul O'Keefe got
Yeah.
on there and said, "Yeah, I brought him in. Yeah, I brought him in for just that to let them know that we don't buy none of this crap."
Mhm.
Okay, okay. Um, I just, anyway, I just
I
think
have a hard time with their that.
the sad part is that this doesn't get justice for his brother.
Right.
Like, none of it. None of it on either side. Eh, 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 Them intimidating Turtle Boy, um, to the extent that I mean, the whole thing, and that's what I don't get. Like, why does it have to be so ugly that a person is thankful that somebody's mama died?
Right.
I
Hey,
don't give
Brenda.
two craps. Hey, Brenda, I don't give two craps what you think about Turtle Boy. That's not okay.
Right, right, right. It's not.
And and so I don't understand why can't we? Okay, did you leave the thing up? It's kind of like
Yeah.
they were saying on Coffin Deffer's thing today. Okay, if you disagree with her, she says you're drinking the Kool Aid and you're trying to make money and all that. So how am I trying to make money?
Mhm.
Because I don't believe Karen Reed is guilty.
Right. She's gone again.
She did it,
She's back. You're back.
bruh.
Mhm.
I just, I looked at the science, I looked at the evidence, and I don't believe that she did it.
Yeah.
And so for me, that's very patronizing for someone, I won't even say her name, for someone to get up there and say, well, if you're doing this, then you have an agenda and you've drank the Kool-Aid and blah 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 blah. I don't understand that. I don't understand that. And these people that have these platforms, they're the problem. They're the problem. So,
Mhm.
anyways.
So we got about 15 minutes because I have to end at 10 o'clock, and I want to watch the last
Oh yeah, yeah.
the the
Are you gonna
comparison.
turn into a pumpkin?
No, why?
Because you said you have to end at 10 o'clock. I used to tell my kids I turned into a pumpkin at 10 o'clock,
Oh,
so they better get
I
what they
will.
needed
I
before 10.
could. I could turn into a pumpkin, but no.
Um,
I promised Dale that I would be done and wrapped up at 10 because he's got to go to bed for work. Um, and I'm in the bedroom, so
and you've locked him out.
he's locked out. So I got to end at 10 o'clock.
When I first started watching you before I knew you had a clofus, and you were like, I locked my husband out of the bedroom, and I was like, ma'am, is that do you want to be saying that like on the YouTubes? Do we need to know all that? And then I found out about your clofus, and I was like, oh, it makes sense
Mhm.
now.
Yeah.
Yeah.
Take you out to the
So
I can't because I gotta take care of the kiddos.
no, she promised.
Yeah.
She
Yeah.
promised.
Yeah. I did. But so we have let me see, let me find it. She's like, "Yeah, husband's home. Let me go lock the door." The only reason I did that was because when he's home, I can officially lock the door and know that he's got charge of the kids. And otherwise, I have to leave the door open, during the day when he's not home because the kids are in and out and let me know when they need things and I can check on them easily, that kind of thing. So, all right.
Play
Now
it.
comparing, um,
Let me just say this to keep in
okay.
mind. These are 2 different states,
Absolutely, they are. I was gonna
and they
mention that,
do
yeah.
and they do things differently. However,
Mhm.
that doesn't mean that Bev couldn't have
Done
clarified
this.
this whole thing. I mean,
Well,
it
what
would
I
have been
was gonna
so
say
easy.
what I was gonna say is that he for those of you that didn't watch this trial that we speed watched this trial, um throughout the days whenever the Karen Reed trial was not in court or whatever. And this is the Karen Swift trial. If you haven't seen this, you can go back and watch it, but it's spoiler alert, it does end in a mistrial. This is in Tennessee, it's not Massachusetts.
I love this
Um,
judge, though.
but this judge, when they come to an impasse, um, he has this little, I don't know what you want to call it, a little discussion with them and gets more information as to, because there were 3 or 4 counts. There were a few counts that, just like with Karen Reed, there were a few counts. I know things work in different states and stuff, but
Right, right.
she
I just
could have
wanted
done
to.
this. She could have
Oh,
done this.
absolutely.
So Bev, you should take um whichever direction on your computer screen that you're looking, you should take instruction or direction or follow this Judge Mark Hayes from Tennessee. You should follow
It's to
his
your
lead.
left. It's to your left.
There.
Wait, the TV's behind, so now I'm waiting to see. Yes, there. Yes.
Okay. See, on my screen, I'm pointing away
I
from
know.
him. He's
Yeah.
over there. But
No.
anyway, okay.
Yep.
So
Over there.
he's over there. But here
Over
you
there.
can see we streamed this trial. So you're going to see this little thing here of me because it's where I streamed this on the channel. So don't be confused. This is old past me.
Don't
And
be
this is,
talking to the past stream like
yeah.
QB likes to do.
All right. So just watch how he handles this when they do not have an agreement. This is what Bev should have done.
Either way, if you cannot remain silent when the jury comes in, now's your opportunity to
I'm
leave
going
the
to mute
courtroom.
myself.
Um, I'll be glad for you to do that. Any reaction expressed out loud is you'll be immediately escorted from the courtroom and may be subject to being held in contempt of this court.
I'm always like, how do you know that you're like, don't plan to have a reaction, but then you have a reaction? I mean, like, I would be like, okay, yeah, I can keep it cool. I can keep it calm.
Ready to go? Ready for the jury? All right. I'll show you whenever you're ready, if they're ready.
And then if you have a reaction, like what? You know what I mean?
All rise.
Mm-mm.
All right, let's have a seat. Good afternoon to you all. Madam Foreperson, has the jury reached a verdict in this case? Do you feel like that it is likely that the jury on continued deliberations will reach a verdict?
No, sir.
Let me also just say that Bev didn't ask them that. If she did, I missed it. I don't remember her
No,
asking.
she didn't. And so, and I don't want to interrupt, but I want y'all to pay attention to the difference in his demeanor and her demeanor. It was like when they came back and asked for that cert report, and she said, "Y'all have all the evidence that you're going to get." Okay, that basically, if I was a juror and I didn't know better, and the judge is the judge, I would think there's no reason for us to come back out and ask any questions or ask for any clarification because we have all the evidence that we're going to get.
Mm-hmm.
And so, and like you said, she didn't say to them, you know, like when they came out the first time, she's like, go have a Snickers, maybe a nap, and then y'all keep talking.
Pretty
You know,
much.
it wasn't like, we appreciate your hard work. We appreciate what you're doing. We're going to ask you to go back, go have some lunch, clear your head, you know, and y'all talk. Would you mind talking about it some more? And even ask them like this judge did and said, do you think if you go back and talk about it some more that you might be able to work things out?
Mm-hmm.
Anyways.
Yep. That's basically what he said. Let's watch it.
It is likely that the jury on continued deliberations will reach a verdict.
No, sir.
Let me ask you this. Has the jury considered the highest level of the offense?
Yes, sir.
Is there a disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls.
No, I'm sorry. It is not. That is not the case of the highest.
Okay. Does the jury agree on the highest level of offense that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Okay. So the jury has found the defendant not guilty of first-degree murder.
Yes.
Okay. May I borrow the charge book for a minute so I can look at the verdict form? If you need it back to look at it, just tell me.
I'm just going to speed this up a little bit.
Is there an agreement? Has the jury considered the second level of the offense attempted first-degree premeditated murder?
We did consider that.
Is there an agreement that the defendant is not guilty as to that offense?
Yes, sir. There is an
Has the jury considered the level of offense second-degree murder?
Yes, sir.
Is there an agreement that the defendant is not guilty as to second-degree murder?
Not guilty.
I have not asked you specifically, but are all of these agreements unanimous as to these levels of charges?
Yes, Your Honor.
Okay. Beg your pardon? I'm sorry. My question, I'll come back in. My question was, is it unanimous that the defendant is not guilty of second-degree murder? And I'm going, since there was it's my question. Is there an agreement on that level of charge?
Agreement with who?
No.
Oh, I'd say not guilty on that.
Sir, ma'am. Not guilty as to second-degree murder. Is that correct?
Correct.
Okay. That cleared that up, General? Has the jury considered the next level of charge, attempted second-degree murder?
Yes, sir.
Do you all find the defendant not guilty of attempted second-degree murder?
Yes, sir.
Each of you,
There were multiple. No audio? You can't hear that?
ma'am? Okay, I'm looking.
Oh God, can you guys not hear that?
I can hear it.
Oh, Steph says no audio. I was like, God, are you all sitting here and nobody can hear it?
Looking at you because I want to say, and if you disagree, just let me know, okay? Now let's go back. We did not do this as a first-degree murder
Hey,
charge
Spins.
that I'm told you found him not guilty of. Is that correct?
See how he's even like, I mean, he's like specifically, they go through each and every count until he gets to the one where they cannot agree. Okay.
And that's the thing. It's like it literally took him what, 10 minutes?
Yeah.
15 minutes at max? This trial went on for 9 weeks.
Mm-hmm.
I mean, I don't know.
Okay, I
He
see
goes
the
on
head
through.
nodding affirmatively, and attempted first-degree murder. Is that correct as well?
He's going
Okay.
through and double checking again. He's even double and triple checking everything, right? I can understand
jury
not
considered
doing
the
that
charge of
whenever you just have a guilty or not guilty. But when you got a handful of counts and you know that everybody's not going to agree or that there's the opportunity for people to all not agree on all of them, then I just don't understand why it didn't happen.
voluntary manslaughter?
Yes, sir.
Is there an agreement, or has the jury found the defendant not guilty of voluntary manslaughter?
There was no agreement.
No agreement? Is that the level of the offense at which there is disagreement?
Yes, sir.
Is that correct, ma'am?
Yep.
All right. Would the state like the jury polled as to the first 4 level of charges? Or as to the level on which there's a disagreement? I think since we don't have a verdict, there's no reason to poll the jury as to that level. You agree, Mr. Taylor? I'm going to ask each of you this question. You just tell me, would further deliberations be of any value?
No, sir.
Do you all believe that the jury is hopelessly deadlocked with respect to the charge of voluntary manslaughter? I see everybody nodding their head yes. The court will enter a verdict of not guilty as to the charge of first-degree murder. The court will enter a charge of not guilty as to attempted first-degree premeditated murder. The court will also enter a not guilty verdict with respect to second-degree murder. And the court will also enter a not guilty verdict with respect to attempted second-degree murder. The court believes that the jury is hopelessly deadlocked with respect to the next level of charge, that is voluntary manslaughter. Is there any reason that the court should not declare mistrial at this time, General? Mr. Taylor.
And then he even asks right there, is there any reason why the court should not declare mistrial at this moment?
And that's how it's supposed to be.
Mm-hmm.
court will enter and declare mistrial with respect to the charge of voluntary manslaughter.
So that's basically it, okay? And then I wanted to just quickly come over here and watch Bev's. Just for funsies.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
That's what I took away from, and that's it. That was it. That was it. So, QB, do you think that does everybody in the chat think Bev needs to take a page out of
Bev, if you're
Judge
listening, and
Cody's?
we know you're listening, ma'am, go back, watch the Crime Cafe from when you were down, at the Cape, and we're off for weeks on end. Watch the David Swift trial. Watch that judge. Learn from him. Take 10 minutes. Take 10
I
minutes.
bet she wishes she had.
I don't know that she does. I don't know that she does. And here's the whole thing that I've said this whole entire trial. If there's not something sussy, stop acting like there's something sussy.
Mm-hmm.
Cut it out.
Mm-hmm.
Like, if you ain't trying to hide something, then stop acting like you're trying to hide something.
Right. You would
You
think that
know?
she would be super like hyper focused on that anyway, and that she would
I mean,
try
like,
hard not to.
I just don't get it. And I mean, that goes to her, to the McAlberts, to Higgins, to Proctor, to Lollygag, Lollipop, Lolly, whatever. It goes to all of them. If y'all ain't trying to hide something, stop acting so suspicious. Don't be lazy. I mean, if you're just lazy, then how about don't be lazy for a minute and not create doubt? Okay, if you're in a hurry to get to the Cape, how about take just a minute and clarify? Then there's no question. This is easy. This is easy.
The only
And
thing that I struggled with before was I had written down the part about them not consenting to the mistrial, but like you said, I agree. Everything was just kind of like woo, and then they were like, "Oh, wait a minute."
they didn't consent
still,
or not consent. They didn't do either thing. And honestly, I think in the middle of it, I don't know, like you said, they don't play checkers, they play chess. So, and there is talk in the crime streets that they did that on purpose so that they could file this motion and do a whole PR thing to try to, keep them from doing another trial or whatever the case may be. I don't know, that makes about as much sense as some of the conspiracy theories. You know what I'm saying?
well,
I
I
don't
guess
know.
so too, but at the same time, I still just feel like that if it would have been like a rookie mistake to have skimmed on past
But in that
on
moment,
either side.
On-
I'm not going to say on Lally's side because
he
he's just sitting there with his twiddling his thumbs, waiting for that cigarette. But
the problem is that at the end of the day, Bev is the gatekeeper.
true. She's
She's
the
the
one
gatekeeper,
that's over
and
that courtroom.
she should have made sure that. I mean, do you think that the judge in Swift? I mean, he didn't have to do all that. He did that because it's proper, and because you put it on record, and you put it on. You get it in the court record, so there's no question when they come back to try to retry him.
Right.
And now it's like this whole entire thing, and I know Dale wants to go to bed. This whole entire thing is shrouded in crap.
Right. I
It's
know.
crap. From the red Solo cups to the leaf blower to the Trooper Paul to all of it.
The red Solo cups and the ShopRite bags.
I mean, they went across the street to a cop who had the red Solo cups. What? I
know it. I know. All right. I got to get out of here.
Yep. All right. Are you streaming tomorrow?
Yes. Friedale's bedroom.
Friedale's bedroom.
Patricia. Hey,
Hey,
Patricia.
All right,
Patricia,
I'm out.
did you see the QB? Thanks for popping up. And I'm glad that you were able to come up and give us your QB words. You should have been in here. What was it? A couple days ago, there was some new faces popping in, and we were all telling all these new people about QB and how they're going to love QB.
That's so sweet. That's so sweet. I wish I would have been there when Mona came in.
Oh, well, we took care of Mona.
You did. Let me just say this real quick. I know you want to go. I am so proud of you. Like, I was like, you tell her, girl, tell me to be quiet in my own daggone stream. You be quiet. Get out.
She wasn't telling me to be quiet. She said
she was telling you to speed it up a little bit. Yeah, speed it up a little.
Quit babbling. I'm like, excuse me? I babble. Bye, Mona.
Last time I checked, this is my stream. And you were like, if you want to get to the point, go watch a recording. This is alive, ma'am. It's alive. I was snapping fingers and popping gum. I was like, yeah.
Yeah.
My
it's
girl.
All right.
Anyway. All right. Love y'all. I'll see you tomorrow, most likely. I got PT, but
yeah.
Depending on what time you come on, I'll see you. I'll see you. Love y'all.
Bye. Yeah, that was a mess. But I can't wait for the new folks to meet. We were having a good conversation, Mona, right? It was so funny. I got hung up. I remember specifically trying to discuss, it was a Matthew Perry story. We were talking about Matthew Perry, and I was talking about whether or not the ketamine he got was diluted or concentrated, and I kept getting hung up and was reading other comments, and she was like, you're gonna have to hurry up and get to the part. I'm like, I ain't getting to the part anytime soon, Myrna. Bye. But I'm gonna get out of here so Dale can go to bed. We'll be back tomorrow. I'm not positive yet. I think we might be talking about Lexi Treviso tomorrow. Either that or there's other couple of other things. And I want to do a poll tomorrow too. So make sure it's an important poll. So make sure that you're here tomorrow to vote in the poll because it's very, very important. Good night, you guys. I love you. Thanks for coming and hanging out with me at nighttime in the cafe. Cafe stays open whenever, sometimes, right? All right. I love you guys, and I'll see you tomorrow. Thumbs up, subscribe, like, all the things. #replay. Bye.